How do we tell them if they're on? Yeah.
They're up to their, do you want me to invite them to the call? Yes. Okay. Dean and Don, right?
Yes, we do.
They both been promoted. Should be allowed to talk. Yeah, mute your machine.
But yeah. Speaker.
Should come from the speaker. Don, I can see you if you want to try speaking.
I've got a terrible echo on this end.
Yeah.
So.
All right, Don, you should be coming out of this speaker.
How do I get on? Justin Dean was also on there.
I did promote Dean. Let me see if it did. There we go.
So I see Don, I don't see Dean.
I can see Dean, his camera's off, but he did accept the invitation, so.
Okay.
I'm here.
Perfect.
Okay, we'll start the hearing at 4:12. This is a hearing on objectors' motion to strike. Set up a couple of preliminary questions. Mr. Bowen and Mr. Bowen, you submitted a couple of different documents to Attorney Hartman. You were both the second document that you submitted. What was your intention in submitting that?
Which one specifically would you identify as a second?
What,
The staff reports?
No, it was the one that contained the staff reports. Because I didn't, according to the motion to strike, I was not supposed to read that second filing as of yet, pending the motion. So my question is, when you filed that second document, which contained the two exhibits, what were you intending to do when you filed that?
So there was no second document per se. What we did was
One document.
we filed what we observed to be facts regarding our application and amended to that two staff reports from CRMC.
Included. Okay. So it was your impression that when you did that, you were complying with the scheduling order and filing your proposed statements of fact?
That's correct.
Okay. And the first document that you filed was simply a response to each of the 156 statements that were made by the objectors.
So at Attorney Wagner's request,
Right.
he had shared with us 156 items, of which we reviewed and either agreed or disagreed or found to be irrelevant in this case.
So then, again, what was the second document?
Second, or the document that we filed, not the response to objectors, the document that we filed was a statement of facts relative to our case.
And that was filed prior to March 29th in accordance with the order.
On March 29th.
Well,
So it is the case that you have not looked at that document?
I have not. So the purpose of the pre-hearing conference and scheduling order was to consolidate things so that we can hopefully come to a set of agreed upon facts and disputed facts. Know that you've chosen not to engage legal counsel. We're trying to accommodate that, but by the same token, you still have to play by the rules, and that's part of the motion to strike that was submitted by the objectors. Notwithstanding that, I think what we need to do is to, in effect, start the process over again, because right now we have nothing. We have 156 sentences, statements made by the objectors. Your one-word responses, this other document that I don't know what it is yet. So, Larissa, did you want to speak to the motion?
Thank you, Mr. Hearing Officer. I am relying on the motion and the exhibits that we filed, but I believe Mr. Libby wanted to be heard today.
Yeah, Don is raising his hand.
Yes, Mr. Levy.
Good
Yes,
afternoon, Mr. Krieger.
good afternoon.
I assume everyone can hear me.
Yes.
Two things, Mr. Krieger, before we get started. The applicants have not filed any opposition or objection to our motion. And I would,
I can get to that yet, but go ahead.
I'd like to put on the record that we're unaware of any opposition they filed to this, and I would suggest that they're not entitled to argue any opposition since they haven't provided us with anything, similar to them filing their statement of facts and not giving us any opportunity to respond to them, either agree, disagree at all. The real purpose of our filing this motion is, aside from having those stricken and you not looking at them, is that we've entered into a scheduling order. We all agreed to it. You entered it as an order. We've complied with it. They don't seem to want to comply with these things. Their cavalier attitude in responding to Mr. Wagner when he suggested to them that the purpose of us doing an agreed statement of fact, as the scheduling order suggests, is to make sure that we agree on facts or not agree on facts, so that we're limiting what happens at a contested hearing. We don't have to have hundreds of witnesses saying the same thing, and we've all agreed in the fact. It's to make a hearing more efficient, and for you, the fact finder, to be able to rely on those as agreed facts that do not have to come in as evidence through testimony or evidence or documents or anything. So what they've suggested in their email response, which we attached to our motion, is that you're going to determine relevancy and you're going to determine whether they're factual and agreed. That's not the purpose of this. And we've all agreed that we will abide by the rules because we have to, and abide by a scheduling order that we agreed to and that you entered as an order. And the fact that they don't want to hire counsel and they're just going to continue to do this. And we do not want this to become a procedural circus. And that's the other purpose of this motion. This needs to stop. They need to follow the rules. They need to follow the scheduling order and do what it says. It's not our burden. We had that conversation at the pre-conference hearing. It wasn't our burden to actually produce any agreed facts until we had theirs. They were given an opportunity on the 25th to send whatever agreed facts they wanted us to look at on the 25th. On the 26th, they responded with a cavalier attitude of, we're going to submit our own thing and we'll let you, Mr. Krieger, figure it out. That's what they said. They never gave us any opportunity to do it. The objectors, on the other hand, sent those 156 or 159 statements of agreed facts with sufficient time for them to respond. We tried to make it even easier for them, and we suggested that you could even pencil in next to each individual paragraph number, agreed or disputed. That would have made it easier. They chose to type it up, follow it, and we attached that document. As far as the objectors are concerned, you, sir, need to uphold your orders and they need to stop violating the orders. And being pro se doesn't mean you get chance after chance after chance. You said to them at the hearing that you advised them they should get counsel. They've chosen not to do it. The objectors shouldn't be the one that are paying the price for this.
Mr. Libby, when you say chance after chance after chance, what are you referring to, Mr. Libby?
I'm referring to the fact that they're well aware of the scheduling order. They're also well aware of what the procedural orders and the management procedures of the CRMC are. They're conversant in the hearing process and the reason and the Administrative Procedures Act. And they know that, if I could, because on November 9th, 2023, Mr. Getz sent them all of that information with respect to what their obligations were in pre-conference hearings, trying to narrow the issues down, all of those things. So they knew about it months ago.
Who sent that to him, Mr. Libby?
Mr. Getz, in an email on November 9th, 2023, he sent 2 emails to them. The first one was captioned Citations Docs, and it included the CRMC management procedures, 1.5, 1.1 definitions, Red Book references, enabling statutes for the Administrative Procedures Act, with respect to a hearing officer. They got all this stuff months ago. And Mr. Wagner, knowing that they really don't know what they're doing, advised them on the 25th of March, you need to send us your stuff. We have sufficient time to respond. And what the response was, we're going to go our own way.
I don't think that's entirely accurate, Mr. Libby, but thank you for your,
And if you could point out, Mr. Krieger, just for the record, if you could point out what is not accurate there, I'd appreciate it.
I think it's not accurate that they've been given chance after chance after chance. I did speak to them about this at the pre-hearing conference. That's correct. They were given a schedule. That's correct. However, also just initially discussed with them the fact that they didn't really comply with the strict terms of the hearing of the order. However, I believe that the courts of Rhode Island have taken it upon themselves to grant a little leeway in this instance, in that this is not a Superior Court, Supreme Court, or District Court case. It's a quasi-judicial hearing, and I think that they've been given one chance and one chance only. I'm going to instruct them from here on in that they're going to have to either follow the rules or obtain someone who can assist them to follow the rules. And you brought up a point that I was going to get to, but thank you for bringing it up. You didn't respond to the motion. You're aware that it was incumbent upon you to answer the motion?
We were not.
Okay. So again, I'm going to allow you a little leeway in this matter. I don't think that either side is going to be prejudiced if we, in effect, start this process over again. I think now you understand that we're going to have agreed upon facts and disputed facts. It's incumbent upon the parties to tell me what those are. It's not incumbent upon me to go through 156 statements and 156 answers and pick and choose out of that. That's up to the parties here. Is that clear? You understand that part?
We do understand now. I would only counter by saying that I believe we're under no obligation to share any information with opposing counsel. And if we look at,
What do you mean by that?
so for us to submit evidence of any kind to opposition attorneys is not something that we're compelled to do.
Or is it? Are you telling us that you are compelled to do that?
I mean, if we had an attorney representing us, then it would in fact be the case that that attorney could speak with opposition attorneys. But under the circumstances, we do not have an attorney.
You
And
can't use that as a shield.
nor do we intend to. If I reference,
You just intended to right now. You just said you're not gonna participate in this process.
well, from how we see it, we did in fact participate in the process as we understood the schedule. So as I read number 2 under the scheduling order,
If you don't agree with a statement that they make, it becomes a disputed fact. Becomes a fact in dispute, rather. If you agree with a statement that's made, then that will be listed as an agreed upon fact, and we won't have to waste time and effort and everybody's breath on it to determine that a week has 7 days. So that's the purpose of the pre-hearing conference, that was the purpose of the order. And I don't think that either side has been prejudiced to the extent that it's gonna impact my ruling on this.
May I just one point?
Yes, go ahead.
So the hearing officer does have the ability to have you concede or agree to certain issues. And this is specifically stated in the Rhode Island General Laws 46-23-20.3. And it states that at the conference, the hearing officer may designate a date for which he or she requires any party to specify what issues are conceded, and further proof of conceded issues shall not be required. The hearing officer shall also require the parties to simplify the issues, to consider admissions of fact and of documents which will avoid unnecessary proof, and to limit number of expert witnesses. This is clearly providing Mr. Krieger with the authority to require agreed and disputed facts.
Which brings up another point. In terms of witnesses, you can't say, well, we're gonna wait till the hearing to let you know who the witnesses are. Just as they're not, it's not trial by ambush, okay? The facts are what the facts are, they'll come out. And once we have all the facts, ones that are in dispute, we'll make a decision.
Hey, Mr. Krieger, if I can follow up on that, and this goes not only to witnesses, but to exhibits. Again, the same statute talks about exhibits, and it says, following the entry of an order, a party shall not be permitted, except in the discretion of the hearing officer, to introduce into evidence in the party's direct case exhibits which are not filed in accordance with the order. So if the order is not followed, there are consequences for that. So if the exhibits aren't submitted in accordance with the order, then they can't be submitted after that date. Unless it's up, and so that's up to the discretion of the hearing officer, but this statute provides him the authority to use that discretion. So there are consequences if this order is not followed.
And the objectors, I believe, did give you a statement of the witnesses that they intend to call and a brief synopsis of what they're gonna say. That allows you to be prepared at the hearing for what is gonna be presented. And if you so choose, you can bring in your own witnesses to dispute that. You know, this is a fact-finding process. That's what we're here for. It's not to hide things or to, you know.
May,
Absolutely.
so clearly, we're not even pretending to be attorneys. We know about oyster farming. We're not pretending to be attorneys. We have absolutely done our best to comply with the spirit of what you have requested without any pretense, just to present what was requested.
And that's why I'm giving you the opportunity, now that I think you have a better understanding of what was required in this pre-hearing order. So I'm giving you the opportunity to get together with the other side and come up with the requested information. You know, if I were to strike everything that was, and by the way, I can't strike what was in their second filing unless I read it. I've done a little on book research, and motion to strike is in order, but in order to issue a finding on that, I have to read what was in the filing. So again, I think the best thing here, everybody at least now you know, that the objectors have a, you know, a legitimate request that you follow, the process. And that process is in the state laws, it's in the, council CRMC, rules and regs. It's all there in black and white. Yes.
To reiterate what my brother said, we have complied with this to the spirit of the law, and if, as I reference state law, that Mr. Hartman just quoted from, and again, as I review the proposed scheduling order, it was never made explicitly clear that it was our obligation to share information with opposition attorneys. And it could be interpreted that the parties, opposition is numerous parties, numerous people, as are we, separate, shall produce an agreed statement of facts, a statement of disputed facts. So in our, it is our contention that what we've done is to produce for the hearing officer a statement of facts.
Of agreed facts that we,
And the facts which can't be disputed primarily because they're events which happened on certain dates. So that was what we understood it to say. And furthermore, I would only say that the state law also requires parties to simplify. And in my reviewing of 156 sentences that were submitted on 17 pages, many of these statements are intentionally not simple and intended to make things more complex.
In that case, they become disputed issues of dispute.
So, I mean, I just want you to understand, it was not our intention to do anything
And I don't-
outside of the bounds of
and I-
the order.
I think I was pretty clear in answering Mr. Libby's initial statement that I don't think that you're deliberately trying to mess with the order or with the process. But again, I can only go so far in allowing you latitude as pro se applicants. As long as you understand that. Again, I think the best course here, Attorney Hartman and I have discussed the timing of this. Attorney Desitel, we're suggesting that both sides have an additional 2 weeks to come up with the agreed upon facts and dispute. And we will also push the other dates back. Yep. Care to be heard on that?
I do, please. To the extent that the objectors are gonna incur costs associated with additional time, I would maintain our objection. We've upheld what we're supposed to do in terms of the scheduling order. So I don't know that it's appropriate to update an order and amend an order and have the objectors go through the same process that we've already gone through. I think we've satisfied our burden, but I would ask that the applicants take another stab at it. I think that would be appropriate if that's what the hearing officer is inclined to do. But the objectors have done their part. We've complied with the order.
Well, don't you still have to participate in the back and forth over what's agreed upon and what isn't?
To the extent that the applicants put together a list of facts, yes, we will review those. I'm just saying it's not appropriate for the objectors to go back and redo everything that we've already did. I just want to make that clear.
we have addressed their statement of facts and we have disputed and agreed as we saw. And we've also submitted our statement of facts that they would be in possession of as well.
We have not been presented with a statement of facts. I believe they were submitted directly to the hearing officer without giving us an opportunity to review them.
Understood. Those were submitted to me, that statement of facts
Okay,
on March 29th. And what I don't want to speak for the hearing officer, so this is what I would recommend, is what we want to see is a statement of fact that's undersigned by both parties that says this is what's agreed to. and this is what's disputed. I don't know how you end up getting there.
Yep.
But whatever it gets there, so Mr. Krieger at the end of the day has, a statement that says, these are the facts that the parties agree to, and these are the parties undersigned, and these are the facts that the parties disagree on, and this is, the parties undersigned. Is that what you're looking for, Mr. Krieger?
Absolutely.
That's what,
In one document.
two separate documents, one agreed, one disputed. But all the parties get together, they work the facts out, whether it's, we've seen from the objectors, their statement of facts and your response, and that's good. We just want to see the end product of that, where you agree to knock out the disputed facts and you agree to put in the agreed facts, and there aren't two documents where we're comparing those, the complaint and responses, essentially. We don't want to see that. We want to see the integrated document. And again, is that what you're looking for, Mr. Krieger?
So we did in fact submit that document.
But we need to submit that to the objectors. Prior.
Yes.
Yeah, I haven't, again, pursuant to the motion that was presented, it was fortunate that at that point that I received that, I had not looked at your second filing, so I'm not prepared to answer that motion to strike that.
Mr. Krieger, I trust that.
Yes,
So in the motion to strike, the objectors raise a concern about ex parte contacts. And I want to cut this off at the head, because what was submitted to me, and which Mr. Krieger hasn't reviewed yet, are not ex parte contacts, because everybody was CC'd on the email that the Bowens sent out, other than Mr. Krieger. So the objectors have seen it. That's the first thing under ex parte case law, whether you're looking at the Chaplin's case, whether you're looking at the Arnold v. LaBelle case, whether you're looking at interstate navigation, or whether you're looking at the Gardner case. Those aren't ex parte contacts because everybody's aware of it. On top of that, I would recommend to Mr. Krieger that they provide the objectors with the opportunity to respond to that statement that the applicants filed. With that, if Mr. Krieger would accept that recommendation, put that into force, then the objectors have had an opportunity to respond to the alleged litigious facts that are supposedly ex parte, and that would remove any concern about ex parte contacts, which this is on its face not.
Yes, the hearing officer,
yes.
Dean Wagner. Are you suggesting an additional 2 weeks from today?
Yes, I was, Mr. Wagner.
So if we're gonna, in a suggestion, if we're going to continue all the scheduling order deadlines, is that an additional 2 weeks to all those, or?
No, I think Attorney Hartman and and Attorney DeSisto will need to take a look at that. I don't think that adding 2 weeks to everything that was in the scheduling order is gonna work. For example, the pre-hearing brief was due by April 30th. And that's kind of a short window to get that accomplished by.
Yeah, the pre-hearing motions are due May 1st as well.
Correct.
So I don't think, I agree.
So why don't we say an additional 2 weeks for the statement of the agreed statement of facts and the statement of disputed facts, and an additional 30 days on the other deadlines.
And we can anticipate a written order, right? Because
Yes,
my calendaring is not trustworthy.
yes.
Thank you.
And Mr. Krieger, if I might, so what you're suggesting with this 2 weeks is that we will be answering or agreeing or disputing the applicant's statement of facts. And then we're integrating all of those into the 159 that we've already produced and served.
Well, I think those have already been completed. We've already submitted the 156 items, and the applicants have answered the 156 items. So I don't believe, I believe that we're only looking at their on facts.
So I'll, if I could, Mr. Krieger, what Mr. Libby's referring to is the submission that was made more recently on March 29th by the Bowens, included their alleged agreed statement of facts. There were, whether or not they agreed is disputed, but they were facts that the Bowens believe are true, and it would be appropriate for the objector to have the opportunity to respond to those particular facts. Whether or not they're integrated ultimately into the agreed statement of facts or the disputed statement of facts that's presented to you, that's up to the parties.
And does that include the 2 documents that were attached to their filing?
So Mr. Libby, those documents, those are staff reports, and again, under the, I want to address the ex parte issue again, under the ex parte context case law, staff reports don't fall under that. Staff reports are that the council and Mr. Krieger are authorized under CRMC's enabling legislation to consult experts. And that includes the staff and their reports. So it would be my recommendation that Mr. Krieger not strike those, unless you have some sort of objection where you think that these documents that were submitted were somehow altered by the Bowens. I'm not, other than that, I don't see why a staff report should be stricken from the record.
Well, if I could, I would suggest that's premature for the simple fact that it's a fact that there's a staff report or 2 staff reports. What's inside the staff report is subject to dispute and cross-examination. So if you're suggesting that the staff report is taken as a fact, I would object strenuously to that.
I'm not suggesting that.
Simply because they were, so first off, please, if you would, if you have an objection to that, these staff reports, please put the objection in the record saying that these shouldn't be accepted as agreed to. And again,
Well, the document shouldn't be an agreed statement of facts in the first place.
Right.
Let's just, we shouldn't be attaching documents to the agreed facts. So it makes it that simple. They just need to understand that they shouldn't be submitting documents at this time. There's going to be an opportunity to submit exhibits at a later date.
absolutely, that's correct, Mr. Wagner. But nonetheless, the staff reports are the staff reports. Whether or not they should have been submitted, I think that the fact of the matter is they're already in the record.
They're already in the record, and they will be brought forth at the regular hearing.
Yes, they'll be brought forth by staff. They're already in the record.
And you will have the opportunity to cross-examine the biologist, the aquaculture biologist, who wrote the staff report.
If I may, it was our contention that these staff reports were in fact issued, and we amended them as evidence of such.
Yes, but those should have been submitted as exhibits in that case, which is later down the line. And even at that they already are part of the record because they are the evidence of staff. And will be presented as such by staff when the hearing eventually comes through.
And you can present your own witnesses to buttress the staff reports, just as they've already listed witnesses that will dispute the staff report.
Yeah, actually, Mr. Hearing Officer, they're not going to present any witnesses as far as we know.
Say that again?
They're not going to be presenting any witnesses as far as we know, and they should be precluded from presenting any witnesses pursuant to your order.
That's what we had submitted. That Patrick and I will be,
We will not be submitting witnesses.
we will not be submitting.
But we will be cross-examining any people here.
They've, I believe that was their statement that was given to you by email in response to Attorney Wagner's email.
It was in compliance with the schedule.
That's not correct, Mr. Krieger. There was a date for a statement, a witness statement from, or a list of witnesses, including their name, address, and a short statement of what their intentions to testify were, that were due
March 1st.
March 1st. We produced a 17-page, I think it was, list of witnesses and their intended or expected testimony. They submitted theirs that said they are calling no witnesses.
Correct,
Zero.
That's correct.
That's correct,
Yeah,
Mr.
I misspoke in terms of saying that it was in response to Attorney Wagner's email, but I have all the emails here, Mr. Libby. If you want me to go through them, I can, but I believe they said it 2 or 3 times that they don't intend to call witnesses, except as a in response to any witnesses you may have brought forth at the hearing.
Right.
Well, that would be, if I could, that would be considered rebuttal witnesses. So on the record, they're not calling any witnesses at all. I just want to be absolutely clear that that's the case.
I believe that to be clear, the hearing officer's order provides him discretion to make adjustments if he deems necessary at the time of the hearing.
And how do the objectors prepare for witnesses that within his discretion, he may decide to call, the Bowens may decide to call on the day of the hearing?
Well,
That was
they
the
can't,
purpose of the scheduling order, was to
they can't
put
just-
that information forward.
they can't just show up at the hearing with a mystery witness without having provided notice to the parties.
This may be premature, but they didn't even put themselves down as a witness. How are they going to testify if they didn't even put themselves down?
Mr. Libby, I just want to be clear. This is an administrative proceeding. We are not in Superior Court. We're not in Supreme Court. We're not in District Court. This is an administrative proceeding. You can argue the complexities of the procedure here, but the fact of the matter is they're an applicant for a CRMC aquaculture permit, and they get to present their case as they wish. Now, the hearing officer has his abilities to corral the parties, and that's what we're here for. And we've made it so that the hearing officer has discretion at the day of the hearing, and he can exercise that discretion. If you have a problem, the way he exercises discretion doesn't give the objectors an opportunity to take time to prepare for witnesses that are allegedly surprised, then that's something that you can take up with the Superior Court under 423515.
Okay, so the scheduling order really doesn't mean anything then. I'm really concerned about that. We're following the order. We were required to do something by March 1st. The objectors did it. They produced no witness list at all. And then yet there's discretion for them on the day of the hearing with respect to Mr. Krieger.
It's not discretion for them, it's discretion on behalf of the hearing officer.
I just said that Mr. Krieger could say, yes, you can produce that witness on the day of the hearing. And my question is, what's the purpose of the scheduling order then? This is a quasi-judicial thing, which has rules. It has a scheduling order that everyone agreed to, and yet certain parties are not adhering to it.
Mr. Libby, I addressed that immediately after you were finished with your tirade in the beginning, okay?
Well, first of all, with all due respect to you, there was no tirade, and I object to you.
Well,
even
was.
saying it for the record.
You made several statements, Mr. Libby, that I don't think a Superior Court judge would have allowed you to say, okay? So this is not the Superior Court. We're gonna go back, give everybody a chance to comply with the scheduling order, Okay?
Mr. Hearing Officer, it's Dean Wagner.
Yes.
Could you just, could we just make it clear to the applicants, because I think they might misunderstand, it's not untoward for them to talk to us. So they have to understand that because they don't have an attorney, we're trying to work out this statement of facts. It's okay for them to talk to us. I just want to make sure they understand that. Thank you.
Thank you.
Yes, you're adverse parties, but in order to move the hearing along and to come to agreed upon statements of fact and disputed ones, you have to get together to talk about these things. Or you can do it by email or however you want to do it. You don't have to get in a room and go over it, but no. Mr. Libby, I'm sorry if I was a little abrupt, but again, I don't think that I've given the applicants any more consideration than anyone would. Okay, but by the same token, I've made it very clear that my discretion has its limits, and the simple fact that they are pro se and intend to proceed on their own is not going to favor them in the future. Understood?
Very much so.
Thank you.
If I may, request some clarity relative to what Mr. Hartman said moments ago. The objector's motion includes a claim that we have filed ex parte communication. And I would just like some clarity from you stating that it is not in fact the case.
I can't tell you because I haven't read it. I didn't read it because their motion specifically requested that I not read that document as they're contending, they initially contended that it was an ex parte communication, which I think Attorney Hoffman has addressed.
But there is no evidence of that whatsoever.
No, that's correct. So the concern with ex parte contacts is that there are litigious facts that are reaching the hearing officer off of the record. And that hasn't happened here. As you heard Mr. Krieger say, he hasn't looked at the documents. So there are no ex parte contacts in the first place. However, even if that were the case, and it's not, the fact of the matter is the objectors have an opportunity to view it because they were all CC'd on what you submitted. And that makes it so that they're not ex parte contacts. And I would recommend to Mr. Krieger that he gives the objectors the opportunity to respond to those facts. And sounds like the objectors will respond to those facts. Again, that prevents ex parte contacts if they have that opportunity. So as far as I'm concerned, I don't see an ex parte problem here.
Thank you.
And we will draft a brief order containing the specifics of what we've talked about here. And we will also include in that the dates of continuance. Spencer, do you have anything?
I do not. Thank you.
Mr. Wagner, do you have anything else?
No, Mr. Hearing Officer, I don't. I just want to clarify, how is that, did you expect us to submit an order, or how is that going to be done?
No, we'll draft it.
We can draft it, Mr. Wagner.
Okay,
We'll
okay,
draft
thank you.
it and circulate it.
Thank you. I
Mr.
have
Libby, do you have anything else?
No, thank you, Mr. Krieger.
Thank you. Mr. Bowen, do you have anything else?
At this time, thank you very much. I appreciate
Okay,
it.
so the first date then will be 2 weeks from today for the agreed upon and disputed facts. Okay? Thank
And
you.
then for 30 days for the following.
30 days.
May
uh,
2nd.
Yeah.
May 2nd is too.
All the other dates will be pushed back 30 days.
Anything else? Are
Thank
good?
you.
Thank you.
Thank you. everyone.
Thank you.
My car is going to be towed